The future of the New England Clean Energy Connect corridor seems uncertain today after a Superior Court judge ruled the permit for the line to cross a mile of state-owned public land violates the Maine Constitution.
That ruling came yesterday. News Center Maine's Don Kerrigan joins us live from Augusta tonight. So Don, so far leaders of the NECEC have been silent on this.
They have indeed, and that they've only made one very brief comment. Opponents, meanwhile, filed a request late this afternoon to the Department of Environmental Protection to stop all the construction on the New England Clean Energy Connect project. That was not a surprise, as opponents have been saying for the past day. They want all the cutting stopped while the state, the company, and the courts figure out what's going to happen next. The new section of the corridor runs through 53 miles of woods. NECEC leaders say they own or have easements on all of that land, except for a mile of it on state-owned public reserve land, which opponents say is shown in this video. CMP has a permit to run the power line across that state land. Maine's Constitution says a substantial change for that land, such as the transmission line, requires a 2/3 vote of the legislature before a permit is issued. But that never happened.
I have said right from the start that I felt that that this is the place that if we were going to be able to stop CMP, that this was the place that we had the best chance to do that.
State Senator Russell Black is the lead plaintiff in the court case Black versus Cutco, decided yesterday by Justice Michaela Murphy. She ruled that the Bureau of Public Lands failed to follow the procedure outlined in the Constitution, and therefore the permit for the line is invalid. Opponents like Black say the ruling is big.
It's going to put a gap in the corridor, and I believe that because of that gap and no legal permit, I think that they need to stop the project and look at the permitting process and get this permit corrected.
How or if that will happen isn't clear. Neither the NECEC nor the Bureau of Public Lands would comment today. Just about everyone, including the judge, expects an appeal to the Supreme Court. Last week, NECEC President Thorne Dickinson told us they believe the new line is not a big change for the land because there is already another power line on part of it.
The standard there is that if there was a significant alteration to the use of the land, and as I think most people know, there is already a transmission line that goes 3 miles across that same piece.
Russell Black says there is a smaller local power line, but not one as big as what is being built. And the court was not persuaded by CMP's argument. Could the project find a detour by moving that part of the line? The company last week would not say if they had alternate plans, and that would most likely require a whole new permitting process. The power line project at the moment goes on, but lawyers for the opponents say they think the court ruling could be crucial.
I think what it means is that they can't build the project, and if the referendum passes, they'll never be able to build a project in this region.
Attorney Jamie Kilbreth, whom you just heard speaking at the end of that report, filed the request with the DEP today on behalf of the Natural Resources Council of Maine. He told us that if the DEP does not voluntarily order a stop to construction, he'll go back to court to try to force that to happen. More to come on this. Chris and Cindy, back to you.
You can count on it. Thanks, Don.